Likewise, when you develop something, you might consider this is the commercial version that we want to sell. This is the commercial version of this method, the service that I want to provide. I don't want to make it too fancy. This is what the consumers will want. And that's perfect, again, for your commercialization, for your marketing. But when you're talking about protecting something and protecting an idea, protecting an innovation, you really want to think ahead. You want to think about not just the basic version, but the deluxe version and the super deluxe version and the version for people who like this, people who like that. You really want to come up with all of those versions because, again, it's not required. In order to protect your invention, it's not required that you have it made. It's not required that you have prototypes built. It's not required that you have every little detail worked out. As a result of that, think ahead to the different variations and different modifications, improved versions you'll have, because those are all very beneficial things to include within what you protect, because you don't know where your product's going to evolve to, and likely you don't know where a potential purchaser of your rights, a potential licensee, or somebody else who you may go into business with might think to take your invention, and it might extend even beyond the field that you're using it. A product that might have great applicability in your particular field or where you think it's going to be directed may have great applicability in other fields, and expanding it and describing all of those other aspects right from the outset, doing a little bit of brainstorming, a little bit of dreaming, can often be very valuable to you, because once you've got something in, you need to make sure that everything that you want to protect is in what's presented within the patent office. So think ahead and think to the different variations that you might have. And along those lines, you also want to consider sometimes one invention has multiple components. And the simple way to think about it is that if you can identify elements of your invention that have independent commercial value, that's often something to consider in terms of protection. You might develop a particular software package that takes certain data and transforms it in one way, and then that data is then used to define a set of parameters that are achieved for something else. Well, perhaps the way in which you have come up with this transformation of the data may have use not just in what you're doing with this transformed data, but with what someone else may be able to do in their field. So independent components often have independent and finite value. So these are important things to just think about from the very beginning, because that's the time when the world is at your feet. Anything you want can be done in terms of protecting it. You don't want to find out later on down the line, oh, I wish I had done this, I wish I had taken these steps, I wish I hadn't have talked to that person in advance of this. So there's really a lot of flexibility, and protection and patents don't necessarily need to be as daunting as some people think. The patent office isn't really a proving ground that determines if something works, is it really better or not better. They don't really care if your invention works or doesn't work. They figure if they give you a patent and it doesn't work, nobody's going to want to copy it, so it doesn't really matter. So don't think you have to go so far along, or you need some sort of special technical knowledge or advanced manufacturing degree in order to be able to protect something and get something by way of an invention. And then the last point that I'll mention is the actual patent itself. A patent is the vehicle that's used to give you exclusivity. It's not there to give you permission to sell something. It's not there to give you permission to practice a method. The patent is there to help you stop others from copying what you have innovated. That's what it's there for. It's an offensive tool that allows you to stop others from copying you. Along those lines, if somebody does copy you, it's not going to be a comparison of your product to their product. It's going to be a comparison of that patent and how it's written and the words that are used over as compared to the accused product, the infringing product. I've been involved in cases over the years where the whole case turned on what's the word flat mean. I've been involved in cases that the entire case turns on what does the word taper mean. So the words that are used in the patent application are of great significance, and that's why, for example, I'm a registered patent attorney. What does that mean? That means that in addition to being a lawyer, I had to take a separate exam to be a patent attorney, and I had to have an engineering degree before they would even let me take the exam. So the idea behind that is they want to try, the patent office wants to try to ensure that the people who are helping draft these have an idea of the technical understanding, but also have an idea of the words that are used and are careful in the wording that's used. So that's some general tips to bear in mind when you're thinking about an innovation. And I think the underlying thing that you want to take away from it is don't underestimate where you might be with regard to an invention, with regard to an idea. You might be much further along than you think, and at least with us, it doesn't cost anything to run a question by and say, this is where I am, what do you think about this, so that we can give you an idea as to whether this is the type of thing that could conceivably be protected or might not be protected. It's almost never too early to really get to that phase, unless, again, your idea is, I want the flying car or the rocket to the moon, and we'll all know if we hit that type of technology. Most of the time, you're there. You're ready to at least start on the path towards